All right. Good evening, folks. Good evening, folks. Welcome to Monday Night Law here with Kirk's Law Corner. I'm your host, Kirk Pendergrass. Hopefully, the audio is working good tonight. Doing a double whammy tonight, broadcasting and recording. Hopefully, this works very good tonight. So, I want to go over the petition again and a little bit of history of the law, and so we can kind of understand the right of petition. But our last recording there didn't have the audio in the very beginning for about 7-8 minutes, so apologize for that. And basically, kind of doing a redo with just myself here, and so I can get through this fairly quick. Let's see, put this out there, go to here, okay, good audio on Telegram. Now I'll check for let's see, is that going to show up? Okay. Hi, Cece. How you doing out there on Facebook? Audio coming through pretty good over there? Kenneth, you're over there on YouTube. Can you confirm audio over there? Should be doing good, but hey. Alright. Confirmation on Facebook. We're all good. Hear me just fine. Might actually need to turn that up just a little bit. Alright. Alright. So we're going to pull up this petition here real quick. Did I spell that right? Yeah, I spelled it right. You just want a period there. No. So we're going to go through this again just real quick, what this is, and I made some little changes here and there, but still substantially the same thing, is that this is in the 118th Congress of the United States of America, to the Honorable General Assembly, pursuant to the Constitution of the United States of America, Article 4, Section 4, that the United States shall guarantee to every state in this Union a republican form of government and shall protect each of them against invasion. And on application of the legislature or of the executive, when the legislature cannot be convened against domestic violence. So, right here in the very beginning, they're supposed to protect us from invasion, and we're supposed to do an application to the legislature or petition. If the legislature doesn't convene, then we can go to the executive, which is the commander-in-chief. Okay? I want everybody to understand this, literally, process, because this is due process of law, literally, from the law of the land, because law of the land literally means due process of law, and this is from the Supreme. So this is the supreme due process of law. This dictates the process, and I'm following it, okay? So this is one of those instances where somebody ought to do something about this, and we have to follow the letter of the law. We can't beat around the bush and try to figure something out when the law dictates this already, okay? So it dictates that we go to the legislature for this, and Congress because this is under the federal Constitution. And some of the powers and duties of Congress, which are listed in here, is under Article 1. Okay? We'll be looking at that and confirming that, even though I copied and pasted directly from the Constitution itself. So, the humble petition of Kirkpatrick Assembly sheweth relator on behalf of all similarly situated and all undersigned. Okay? So, for those of you that are at a minimum a registered voter or an elected official under some sort of oath of office, you can sign this. This is how we exercise political power. Okay? So I know some people have a little him-haw about being called a registered voter. It is what it is for right now until we fix our Republican form of government and get back to government de jure. This is the way it is, and this is how it works. So I'm not here to make arguments about that kind of stuff. I'm just wanting to get the job done. So, as most of you are aware, that I spent 10 days down in Arizona with Jonathan, and I thank my brother Jonathan for hosting me down there out of his own pocket, folks. Okay? Which he's done with so many different people, including Senator Phil Hart, so from Idaho here. Number one, that there is a foreign invasion happening on the southern border between Mexico and the United States of America, where men, women, and children unlawfully enter into the several states, including California, New Mexico, Nevada, Arizona, and Texas, which Border Patrol and other organizations are aiding in. Now, this is key to understanding what's going on here. Is that Border Patrol and other organizations are aiding, such as doing food and water drops. Okay, that's those other organizations, which the cartel are actually accessing that, which Jonathan has the video evidence of that happening. Okay. As well as a plethora of evidence about Border Patrol being involved. Okay. They're just following their orders and doing what they're told. And some of them are actively engaged in helping and aiding. Okay. Evidence. Number two, there's trafficking of men, women, and children happening on the southern border between Mexico and the United States of America, where men, women, and children are unlawfully entering the several states, including California, New Mexico, Nevada, Arizona, Texas, who are being bought, sold, raped, and murdered. Okay? Pretty sure by now a lot of people are aware of this stuff, but the fact is nobody knows what to do about it. It's like the multi-million-dollar question for just about everything that we come across is, well, what do we do about it? What do we do? What do we do? Read the supreme law of the land and follow it. Learn what our rights are and follow it. Okay? That's the ultimate answer. Remedy and relief comes from the Constitution and our rights. Our rights dictate this process. This particular one from Article 4, Section 4 is from the Supreme Law of the Land, so it dictates this process, but it's coupled with the right to petition, sometimes referred to as the First Amendment, Article the First. Okay? And then, of course, the drug, fentanyl, is unlawfully imported in the United States of America without going through any ports of entry. So this is what we're demanding an investigation. This is where we make our demands. This is under what's known as a prayer for relief. And this is what the clear distinction between a petition and a remonstrance is. It has this section right here, and this is what is the distinction between a petition and a remonstrance. Petition has a prayer for relief. We get to demand something, where a remonstrance is actually a formal written protest. That's how we protest. Written document. And I'll refer you to Madison's Memorial and Remonstrance. Okay? So you can see what a remonstrance looks like. to declare war pursuant to Article 1, Section 8, Clause 11 for a foreign invasion. Imagine that. It comes right directly from the Constitution itself. The powers. Okay? To call forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Pursuant to Article 1, Section 8, Clause 15. All right? So, this is how it's done, folks. We have to instruct our representatives. I mean, that's it. I'm going to get this sucker done probably tomorrow now. Had too much going on today to break away long enough to get this done, but it's pretty much set up now, and I got rid of the page numbers and all that stuff because God only knows how many pages is going to be for signers here, and I'm hoping that we have hundreds and hundreds of pages. I hope I have to print out hundreds of pages of signers. So make sure you share this particular video here tonight, or even some of the previous videos, but more specifically this one tonight, because I'm really going to dig into this stuff, okay? And no outside interference here. It's just me. So in Lex Parliamentaria Americana, it talks about it must be notarized for the petitioner's signature. So that's why this is set up for notary under oath. This is sworn to or affirmed and subscribed before me this day of October 2023 by me. And then signature of the notary, notary's printed name, the expiration date, and the seal goes over here. This is a proper format for notary for under jurat, under oath. Now I'm going to go into law.cornell.edu here, and this is the annotated Constitution. This is where you see explanation on any of these sections and parts of the Constitution. Okay, so we're going to go back over here to see explanation for Article 4, Section 4. And we'll get into the historical background on guarantee of Republican form of government. And again, why I'm going over this again is because I'm going to be drafting other petitions for other issues. And I want people to learn how this works and what this section is really about, especially the part about domestic violence. Okay? Article 4, Section 4 is generally known as the Guarantee Clause. To guarantee what? A Republican form of government. Okay? Through its terms, the United States makes 3 related assurances to the states. A guarantee of a Republican form of government. That's the number 1 thing. Number 2, protection against foreign invasions. And 3, upon request by the state, protection against internal insurrection, it says, or rebellion, but. And so, this here, what is it, from Black's Law Dictionary, 11th edition, and the Federalist, number 21. Imagine that they would cite that as a source for Article 4, Section 4. Okay? An early version of the Guarantee Clause was one of the resolutions of the Virginia Plan introduced at the Constitutional Convention by Edmund Randolph and attributed to James Madison. The resolution went through several formulations during the debates of the convention. During a key debate, Governor Morse objected to the resolution because he should be very unwilling that such laws as exist in Rhode Island ought to be guaranteed. Randolph explained that rather than cementing the existing laws of the states, the resolution had 2 objects: to secure Republican government, to suppress domestic commotions. Along with concerns about rebellions, debates expressed fears that a monarchy might arise in a particular state and establish a tyranny over the whole United States. That is the domestic violence that is referred to in Article 4, Section 4 here. Is converting us back into the monarchy that we separated from with the Lee's resolutions. Okay. That's what this is really about, folks. And, you know, I covered this a little while ago when I discovered some of this stuff in Bouvet's Law Dictionary 1856, as well as the 11th legislative session for the territory of Idaho. I found this Code of Civil Procedure. And in the second section of this so-called act, it says that the rule of the common law, that statutes and derogation thereof does not apply, and that the code is the law. Well, the code is the Roman civil law, which I found under law, civil in Bouvet's Law Dictionary 1856. And it specifically says the code is the Roman civil law, and it is opposed to the laws of nature, the law of nations, and the law that's common to all. So the common law. This is a subversion of law, and it's a particular part of the Declaration of Independence. In fact, I'll just pull that up so we can actually see it from the Declaration of Independence. Right? Huh? It's not in there? Should be. Where's the Declaration of Independence? That's odd. Did they take it out of Avalon? It'll probably be up here in the D section. Yeah, it's right there. Weird. All right, so where is it? Right here. He is combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, given his assent to their acts of pretended legislation. That's exactly what happened with the Reconstruction Acts of 1871. They converted us back into a monarchy, created the American Bar Association in 1878, and then ushered in the Roman civil law in 1881. That's subjecting us to a jurisdiction, a body of law that's foreign to our Constitution. That's what's going on. That's what's happened. And here it is in the Declaration of Independence, almost like this has happened before, which it has. Okay, so here's history. Clear back to 1776. What they did, why we declared our independence from Great Britain to begin with. But yet, we the people have been derelict in our duties under Article 4, Section 4. So, answering Morse's objection, Madison moved to substitute language that the constitutional authority of the states shall be guaranteed to them respectively against domestic as well as foreign violence. Domestic meaning internal. Back to that Declaration of Independence, that's that erecting, there it is right here. He's erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. That's what we're dealing with, okay? And in Bouvet's Law Dictionary 1856, it talks about how it's all enforced through bills of pains and penalties. Those are them bills of attainder, writs of assistance from these revenue officers. Okay? Let's see. And moving to add the language that no state shall be at liberty to form any other than a republican government. James Wilson then introduced a better expression of the idea, language substantially similar to the final form of the Guarantee Clause, which the convention approved unanimously. In light of its text and framing, the Guarantee Clause was intended to be more than an authorization for the federal government to protect states against foreign invasion or internal insurrection, a power already conferred elsewhere in the Constitution. While the precise contours of what constitutes a republican form of government are debatable, an additional object of the Guaranteeing Clause was to prevent states from establishing monarchical or despotic governments. Now, again, what does it say? We got to do this on application of the legislature. We, the people, have to do this. We're the masters, they're the servants. And it's up to us to claim and exercise this power. All political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. We also have the right to declare war. Period. For a foreign invasion. Except for a brief period during Reconstruction, the authority granted by the Guarantee Clause has been largely unexplored because it's never been used. The Supreme Court and other federal courts have largely declined to hear legal challenges based on the Guarantee Clause because they present non-justable political questions. And I want to reiterate this, that means that the judicial branch has no authority. None. No subject matter jurisdiction. Again, back to learning which branch of government has what powers and what authority over certain different subjects. Okay? It's so crucial to learn this stuff. We must learn this stuff. Brother Diesel D's, I see over here on Telegram. He said he didn't see it on Facebook, but there was Cece was on there confirming audio and stuff first thing. So I don't know, unless Facebook decided to shut me down. But yeah, this has nothing to do with the judicial branch. This is political, which we'll get into the next section there, which gets into Luther versus Borden, and then Texas v. White. So in Luther versus Borden, I don't know if I can make this a little bit bigger without it. All right. Okay, so in Luther versus Borden, the Supreme Court in 1849 held that questions arising under the Guarantee Clause are generally political and not judicial in character. Again, subject matter jurisdiction. Now, this was Luther was a formerly in action for damages for trespass, but under the rather unusual circumstances of Dorr's Rebellion, a pro-suffrage revolt that led to two competing claimants for Rhode Island's lawful government. Imagine that. There was people competing for lawful government within a territory. The defendants in Luther justified their breaking and entering into the plaintiff's home under a declaration of martial law based on the plaintiff's alleged participation in insurrection. The plaintiff questioned the authority and Republican character of the state government, alleging the defendants to be the insurrectionists. Thus, to adjudicate the trespass, see, this is common law. Imagine that. Common law trespass. Because that's where the term trespass comes from, because our rights is our property. An aggregate of guaranteed rights. So when you violate our rights, that's our property, those unalienable, that's why it's unalienable, because you can't place a lien upon our property. These particular rights that come from the law of nature specifically, but it's also known as a common law trespass when you do. You're trespassing on my property. Get off. But see, they used declaration of martial law. Just saying, folks. I think that's what's coming. Thus, to adjudicate the trespass claim in Luther was in effect to decide which of the two rival governments was the legitimate government of Rhode Island. Okay. Chief Justice Roger Taney held that the political branches of government and not the federal courts should decide such questions. It rests with Congress to decide what government is the established one in a state, as well as its republican character. So, this is why the judicial branch doesn't have jurisdiction. Does this make sense, folks? I hope it does, because this is the letter of the law, the supreme law of the land as it is written. Not my opinion, these are facts of law. And more specifically, how our rights work. So Luther further held that it rests with Congress to determine the proper means to fulfill a guarantee of protection to the states against insurrection. So this is in part where I'm going with this, is the fact that all of our states, we've been foreign invaded by the bar. Right? Each state has its own independent bar association, and these members of the bar have infiltrated our government. They have just enough members of the bar in the legislature to control the legislature. And then there's a member of the bar sitting over there in the corner behind it, every executive agency over there writing their own policy and, internal insurrection. They don't belong there. What are they doing over there? Ignorance of the law is no excuse, and to know a thing and to be bound to know it are regarded in law as equivalent. So if you're a public servant, you can't claim you don't know the law and the Constitution and the limitations of your powers and duties to perform. There's two maxims of law there. So, all right. So, this is what's supposed to happen. We're talking about getting down to the state level. Although the court suggested that Congress might have empowered the judiciary to decide whether the federal government should intervene, Congress has instead authorized the president to call out the militia in the case of insurrection against a state's government. It followed, reasoned Chief Justice Taney, that the president must of necessity decide which is the government and which party is unlawfully arrayed against it before he can perform the duty imposed upon him by the act of Congress. This political determination is not subject to judicial review. Okay? So, this is why it specifically reads in Article 4, Section 4, on application of the legislature or the executive if the legislature can't be convened. Okay, it's up, and this is in fact what is actually going on and has been going on since Trump took office. This was the whole plan, the continuity of government, the two federal directives, because they knew that the United States Inc. as a corporation was going down. They're taking this stuff down. Okay, Reconstruction Acts of 1871, they've already been made void. Okay, so technically speaking, we don't even have government at all right now. We are actually under martial law because we are at war. That's what the Executive Order 138181 does for those involved in serious human rights abuse and corruption worldwide. Which is why many different nation-state countries over there, that the good guy military has went in and taken down the corrupt government and instituted new people and created democracies, had new elections for their representatives over there, and then did a treaty of peace. How do you do a treaty of peace if we're not at war? I mean, come on, folks. This has been happening since 2017. You know, remember when Trump did the sword dance over there in Saudi Arabia? Yeah, that's right, because he took that down. Why Trump walked in front of the Queen in England? Because England was taken down. Why the Pope had such a sad, dreary look on his face when he met with Trump? Because he knew the gig was up. There's no smoking and joking going on there with Trump. Like previous presidents have been smoking and joking and laughing and having a good old time over there when they meet. Things were a little bit different when Trump went over there. That's symbolism. Those are your signs of change. Okay? And this, again, goes back to even what Attorney General Barr said back in like 2018, that Trump was going to start, the executive branch was going to start executing powers that properly belong to the executive branch, and the judicial branch can just deal with it because they don't have any authority over it to begin with. None. This is why we're trying so hard to impeach Trump, because Trump was taking down the deep state. Okay, and this is the reason why they're still trying to get it so that supposedly he can't come back in. We're at war. This is the deep state versus the good guys here. And it's really about us, the people. Because it's supposed to be our republic if we can keep it. So it's going to ultimately be up to the people, like Trump said in his inauguration speech, that he was putting the power back into the people's hands. What power do you think he was referring to? That would be that all political power is inherent in the people. We have the right to alter, reform, or abolish anything at any time we deem it necessary. But ultimately, we have to reassemble the General Assembly to start exercising that power. Okay? That was the whole thing about the Reconstruction Acts, and Congress didn't. Congress had walked out, sine die. Well, sine die just means without a day. But the Constitution calls them back in, so it's not necessarily, it's not a day of return. There's no day of return because the Constitution already dictates that they come back in annually. Okay? So again, back to over here. During the Reconstruction, the court in Texas v. White posited that the president's actions in establishing temporary state governments in the defeated Confederate States at the end of the Civil War was justified as an exercise of his powers as Commander-in-Chief. Okay? Not as president, but as Commander-in-Chief. And so this is what has been going on since Trump took office. Okay? And why Trump said we're going back to 1776, which is a revolutionary war. And it's up to the people to come together, reassemble this darn thing. It's like an engine. We got to rebuild this thing in order for it to run correctly. We got to build it. All the moving parts have to all be assembled correctly with the proper timing. Right? Everything's got to be all buttoned up correctly and properly timed so that this thing runs like a well-oiled machine. Now, a lot of people do not grasp this concept of the statuses that we have here in America, which is the inhabitants, the people, and citizens, which are the members who are bound by the Constitution, those elected officials who are appointed in a position of public trust, that are required to be bound to support this Constitution. That's Article 6, Clause 3. Okay? So, because the power to carry into effect the clause of guarantee is primarily a legislative power and resides in Congress, however, those arrangements were necessarily provisional. It was generally up to Congress to organize and recognize new Republican governments in these states. That is Article 4, Section 3. Okay? The next major controversies on the Guarantee Clause arose in the Progressive era, where various state popular democratic reforms were alleged to destroy the Republican form of government ensured by the clause. In Pacific States Telephone and Telegraph Company versus Oregon, the Supreme Court in 1912 declined to address a claim that a popular initiative and referendum provisions of Oregon's Constitution violated the Guarantee Clause. Relying on Luther versus Borden, the court dismissed the case for lack of jurisdiction as a political question conferred upon Congress and not, therefore, within the reach of the judicial power. Gee, weren't the Brunson brothers told the same exact thing? Lack of subject matter jurisdiction is exactly what the district court, the trial court in Utah, specifically stated in the dismissal. Lack of standing and lack of subject matter jurisdiction. Because this is a political question, not a judicial one. Imagine that. I wish people would listen and learn. I really do. Considering I'm the one that's actually done the studies and the research, and here's the facts being presented. In later cases, summarily dismissed in similar challenges, Pacific States and Luther came to stand for their proposition that Guarantee Clause questions are never justiciable. Baker versus Carr, despite its general curbing of the political question doctrine, left these Guarantee Clause precedents intact. The Supreme Court continued to follow them through the 1980s. But then, in 1990s, now this is when Agenda 21 started kicking in. However, the court in dicta raised the possibility that perhaps not all claims under the Guarantee Clause present non-justiciable political questions. In Gregory v. Ashcroft, the court suggested that the Guarantee Clause might operate as a constraint upon Congress's power to regulate the activities of the states. More specifically, however, the court has continued to find Guarantee Clause questions non-justiciable despite opportunities to revive the clause. So, again, they tried. Well, maybe not all under Article... If it's under Article 4, Section 4, it's a political question. And it belongs to the legislative branch or the executive. Plain and simple, judicial branch doesn't have any say in this. This, in my mind, was an attempt in the Gregory versus Ashcroft to give subject matter jurisdiction to the judicial. And essentially the judicial branch declined. Said, no, maybe not. Okay? So, I wonder if this is actually going to be true. Supposedly, this is the meaning of a republican form of government. This is really vague. Although the Supreme Court has generally avoided addressing Supreme Court generally avoided addressing guarantee clause questions because of their political character, has occasionally ruled on the merits of such challenges. These decisions, as well as contemporaneous sources, shed some light on the meaning of the Republican form of government, guaranteed by the clause. For example, in the Federalist, number 39, James Madison emphasizes popular sovereignty and majoritarian control as among the distinctive characters of the Republican form. Of the people, by the people, and for the people. Imagine that, folks. We may define a republic to be, see, this is republic, republican, not a democracy. Okay? Not a representative democracy or anything other than, honestly, it's a capitalist confederate republic. That's what the Union is. That's the Confederacy. Because, excuse me, a union is a league of friendship. A league of friendship is a confederacy. It's all throughout the Federalist Papers. Okay? We may define a republic to be, or at least may bestow that the name on a government which derives all its powers directly or indirectly from the great body of the people. Doesn't say American state nationals now, does it? No, it says the people. Which goes right back to Law of Nations, Book 1, Chapter 1, Section 4. The body politic is opposed to the body of the people, and is administered by persons holding their offices during pleasure for a limited period or during good behavior. It is essential to such a government that it be derived from the great body of the society, not from an inconsiderable proportion or a favored class of it. Oh, like parties? Is that what we're talking about? Like parties? Like the Republican Party or the Democratic Party? Yeah, we're not supposed to have parties. Imagine that. Not in the sense that the way it's being used today. Either directly or indirectly by the people, and that they hold their appointments by either of the tenures just specified. Those are those emoluments. Okay? So, it's supposed to be by the people, of the people, by the people, for the people. All political power is inherent in the people. They try to twist this up that it's about the representatives, whether they're senators or representatives in the House there. That's how it's done. Well, that's a half truth. There are powers that are retained by the people. And this is part of what's missing is the General Assembly, our common law grand juries, and our petite juries. Because see, them suits at common law, not suits in law, Article 3, Section 2, but suits at common law. Article the 7th or 7th Amendment. And a lot of this stuff, the thing is this is supposed to apply to them, and the people retain this power. And when we have a bad actor in government, the way it's supposed to work is a grand jury indictment. Well, where does the grand jury come from? It comes from the General Assembly. Uh-oh. Yeah, you got to be one of the people. to have political power. Otherwise, you're just an inhabitant, which is okay. Okay? It's okay to be a free inhabitant and not have any worries about government or any political power at all. That's okay. But you need to learn these words and the real definition of these words from real law of nations. That's regarded as international law. So there's a few people out there that need to change their sources of law. Get away from the code, because that's Roman civil law. Get away from Code of Civil Procedure. Get away from the Code of Federal Regulations. Get away from the Uniform Commercial Code. Code. It's not law. Not here in America. It's not supposed to be. That's all foreign to our form of government and repugnant to our law. So, some of y'all need to change your source where you're getting your information from, especially like definitions and that kind of stuff. That's all bar word salad. It's all been made up by the bar. This code is ran by the bar. The 1874 case of Minor v. Happersett represents a rare instance of the Supreme Court directly deciding the Guaranteed Clause issue. In Minor, the court addressed whether Missouri's denial of the right to vote to women complied with the Constitution. The court stated the Guaranteed Clause leaves room for states to structure their governments in various ways yet remain Republican. Relying on historical practice as dispositive of the matter, the court held that the Guaranteed Clause did not require women's suffrage because at the time of the ratification, women were excluded from suffrage in nearly all the states, with the franchise only bestowed upon men and not upon all of them. Later, the court held in Forsyth versus City of Hammond that the Guaranteed Clause did not prevent a state from determining municipal boundaries through its courts instead of the state legislature. Well, that's interesting because according to what I read in some of the early legislative sessions for the territory of Idaho, there's supposed to be a land surveyor that does all that. And there was a congressional act for that. Another case, the court found occasions to opine on the nature of a Republican government guaranteed by the clause in dicta. For example, in regards to Duncan observes, by the Constitution, a Republican form of government is guaranteed to every state of the Union, and the distinguishing feature of that form is the right of the people to choose their own officers for governmental administration and pass their own laws in virtue of the legislative power reposed in representative bodies whose legitimate acts may be said to be those of the people themselves. But see, we have to delegate that particular subject in order for them to make a statute. And if that subject isn't in the Constitution, then that subject, there's no authority, no subject matter jurisdiction. Similarly, the court in the United States versus Cruikshank, while adopting a narrow construction of the rights secured by the 14th Amendment's privileges or immunities clause, stated the Republican form of government includes a right on the part of the citizens to meet peaceably for what? Consultation in respect to public affairs and to petition for a redress of grievances as well as the equality of the rights of citizens. How about that right of petition? Yeah. Let's go take a look at that, because that's where I really want to go next is about the right of petition. That's that First Amendment, right? Here's them 5 different aspects, guarantees in the First Amendment is religion, the right of speech, the right of press, right of assembly, and right of petition. So let's go in here to see explanation and what they have to say about the right of petition. You got to go down, scroll down here, because here's your religion, there's your clauses, blah, 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 blah. We get down into here. Yeah, we got to keep going. It's way down here. Freedom of assembly and petition. I wonder if I just click on that one. Okay. Historical background on freedoms of assembly and petition. The right of petition took its rise from the modest provision made for it in Chapter 61 of the Magna Carta 1215. Would you look at that? The right of petition was all the way back to the Magna Carta of 1215. To this meager beginning are traceable in some measure Parliament itself and its procedures for the enactment of legislation, the equity jurisdiction of the Lord Chancellor, and proceedings against the Crown by petition of right. Thus, while the King summoned Parliament for the purpose of supply, the latter, but especially the House of Commons, petitioned the King for a redress of grievances as its price for meeting the financial needs of the monarch, and as the House of Commons increased in importance, it came to claim the right to dictate the form of the King's reply. Until 1414, the House of Commons declared itself to be, as well as dissenters, as petitioners. 250 years later, in 1669, the House of Commons further resolved that every commoner in England possessed the inherent right to prepare and present petitions to it in case of grievance. So, as of 1669, we all had the right to present our own petitions. Imagine that. And the House of Commons to receive the same and to judge whether they were fit to be received. Now, I've covered this in a couple of different videos on the right to petition and reading Lex Parliamentary Americana. That's the real elements of the law and practice of the legislative assemblies in the United States of America. Okay? That's the one we should be reading, because that's parliamentary practice. The rules of the common law dictate this. Not the statutes, because, man, we got to have this stuff long before we create the Constitution, long before we create statutes. Finally, Chapter 5 of the Bill of Rights of 1689, would that be that English Bill of Rights of 1689? Asserted the right of the subjects to petition the king and all commitments and prosecutions for such petitioning to be illegal. Because, see, what was going on, that people were petitioning and they were met with repeated injuries. How dare you come in here with these petty grievances and bother the king? Well, that's how the right works, and you got a duty to perform. And in part, the English Bill of Rights, this is, again, in history, where essentially the executive suspending our rights and certain laws and all this kind of... wait a minute, that sounds like what they just did with the pandemic, right? Huh. Imagine that. Kind of a repeat of history again. I wonder if that says 12 Encyclopedia of the Social Sciences, 1934. Well, why don't we just go to the English Bill of Rights of 1689 and we'll just read that in full. There it is. Let's see. 1, 2, 3, 4, 5. Raising keeping standing armies with. Huh. Well, it said 5. I don't see 5. That the pretended power of suspending the laws or the execution of laws by regal authority without consent of Parliament is illegal. Now, see, that was one of the grievances right here. Did endeavor to subvert and extirpate, that's a hard one, Protestant religion and the laws and liberties of this kingdom, by assuming and exercising a power of dispensing with and suspending of laws and the execution of laws without consent of Parliament. That's exactly what they did with all these stay-at-home, stay-healthy orders and these orders of quarantine, all from the executive branch. By committing and prosecuting divers worthy prelates for humbly petitioning to be excused from concurring to the said assumed powers. So I'm guessing number 5 is actually this one down here. Yep, there it is. That it is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal. Imagine that. That the pretended power of dispensing with laws or execution of laws by regal authority, as it hath been assumed and exercised of late, is illegal. That the commission for erecting the late court of commissioners for ecclesiastical causes and all other commissions and courts of the like nature are illegal and pernicious. So this is when they were abolishing the ecclesiastical courts in 1689. So there you have some history of law, because this is a Declaration of Rights, a Bill of Rights. That the raising or keeping a standing army within the kingdom in time of peace, unless it be with consent of Parliament, is against law. That the subjects of the Protestants may have arms for their defense suitable to their condition and is allowed by law. So that's the thing. This is the one from the Bruin case that they were referring to, of the English Bill of Rights of 1689, that the Protestants in history here were fighting to keep their arms and they were trying to deprive them of their arms. This is one of those instances where the Supreme Court of the United States referenced that section right there as a guarantee to the right to keep and bear arms, which shall not be infringed. Because the right of the people to keep and bear arms shall not be infringed. Now, this is one of those times where the right to freedom of speech gives a little clarity to what the right is really about. That the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. So you got to learn about the history of the right and what it actually means, that the right of freedom of speech has to do with debates and proceedings in the legislative branch, not what you think it means out here on the streets. But hey, people want to construe it to whatever, without knowing facts of law behind it. We're actually talking about the right of the press to publish, to speak on whatever subjects we want to, which being responsible for that is libel and slander. But that's the right of the press to publish, like what I'm doing right now. The right of the press. And here's another key one. and that for redress of all grievances and for the amending, strengthening, preserving of the laws, parliaments ought to be held frequently. That's right. That's why we're supposed to be petitioning the legislative branch for the redress of grievances. And that's what calls them into assembly. Now, this is the one that exposes bills of attainder. Okay? That all grants and promises of fines and forfeitures of particular persons before conviction are illegal and void. So in 1689, this is what they were talking about. Okay? And in Bouvet's Law Dictionary, 1856, under Bill of Attainder, it says legislation, comma, punishment, period. So that's what this is talking about, and why our founders banned, prohibited bills of attainder and bills of pains and penalties. Is any of this legislation that promises these awards before anybody's even accused or convicted. Oh, that's a fine of $500 and a jail time of up to 6 months or whatever. You know, anything that you read like that before you even ever committed it or accused of it or convicted is a bill of attainder, bills of pains and penalties. And then the ultimate question is well, who gets this fine? Whose pocket does this money go into? And did you follow due process of law? Do you have a grand jury indictment? Oh, we don't need that. We can do prosecution by information. Imagine that. All right. We'll go back over here, back onto that right to petition. Supreme Court has asserted a similar historical basis for the right to peaceably assemble for lawful purposes, saying it is, and always has been, one of the attributes of citizenship under a free government. One commentator has noticed that the court originally conceived the rights of petition and assembly as components of a single right, but that the court later treated the right of assembly as protecting a distinct interest in the holding of meetings for peaceable political action. Imagine that, folks. The right to peaceably assemble, to consult for our common good, and then instruct our representatives. Gee, would that be that demand, that prayer for relief, to instruct them to discharge the duties of their office as the Constitution dictates what their powers are? Imagine that. The right of petition, recognized by the First Amendment, first came into prominence in the early 1830s when petitions against slavery in the District of Columbia began flowing into Congress in a constantly increasing stream, which reached its climax in the winter of 1835. Wait a minute. What? 1830s? I thought the 14th Amendment is the one that abolished slavery. See, this is where we're all been lied to, folks. Because right here where my page is set to go to, statutes at large, right, because that's what this is of the United States concerning slavery. 1794, 1803, 1807, yeah, wait a minute. An act to prohibit the importation of slaves into any port or place within the jurisdiction of the United States from and after the first day of January in the year of our Lord, 1808. Oh, you mean immigration? This is where they were talking about in the Constitution itself. The Congress can't make any legislation regarding the importation of slaves until after 1808. Because of this right here. But I thought we abolished slavery with the 14th Amendment. We've been all lied to, folks. It's a big, huge lie. They started trying to abolish slavery in 1794. And in fact, in the Virginia Constitution, the drafted one, had a clause in there to abolish slavery in 1776. Good old Jefferson. Oh, but Jefferson had slaves, blah, blah, blah. It's not like the slavery you think that's been predicated. Okay? There were voluntary servitude. Right? Hey, yeah, I want to come over and I want to settle over here. But, and see, that's the other thing. It was also white people and even some of the prominent people over there in England who still couldn't quite afford to pay to be transported from Great Britain or England area over to America here. And so they became voluntary servitude, not slaves. And they had to work it off, 3 years, whatever, depending on how much land. They would get a chunk of land. Ah, yeah, that's right. So they could establish their residency. They can declare that they are going to settle and be a resident. That's how you qualify to be one of them people. All right. The no petition, memorial, resolution, or other paper praying the abolishing of slavery in the District of Columbia or any state or territories of the United States in which now exists shall be received by this House or entertained in any way whatever. Because of efforts of John Quincy Adams, this rule was repealed 5 years later. See, they were actually trying to stop all these petitions of these slaves who were supposed to be freed in 1830s? Because of those statutes at large abolishing slavery, supposed to come to an end essentially and being phased out after 1808. But apparently that was repealed after 5 years. Now, there was an interesting thing when I was out in Washington, out there, Washington, D.C., in September of 2018, when I was out there with John Gentry and, the things that we were doing out there. We went over to the National Archives, and right on the wall there, when you first go in, you go up those little steps and go to the left, the wall on the wall right there to the left, there was a petition to Congress for divorce. Imagine that. Because she couldn't serve him with the paperwork. She couldn't find him because he was gallivanting around all over the place, right? So she had a grievance. Can't find the man. Will you please grant me a divorce? Because I can't find my husband. And that's pretty much it. It was the gist of it. Short and sweet, one pager. These petitions should be very short and sweet, very clear and concise. No, not all this crazy fluffy stuff. Just like I showed you there in the beginning of this episode here today. Short, clear, concise statements of facts, and that's it. And then what's your demand for relief? So let's see. Okay, let's finish this. For many years, the rules of the House of Representatives have provided that members having petitions to present may deliver them to the clerk, and the petitions except such as in the judgment of the speaker are of an obscene or insulting character, shall be entered on the journal. So here it talks about deliver them to the clerk. Kind of like in the judicial branch, you have a clerk of the court. In the House and the Senate, you have a clerk for the House and you have a clerk for the Senate. Essentially, the paper pusher. That's what the clerk is. I should know. That's what I did in the Marine Corps. Even so, petitions for the repeal of the espionage and sedition laws and against military measures for recruiting resulted in World War I in imprisonment. So, people were trying to repeal, alter, reform, or abolish, right? The espionage and sedition laws and against military measures for recruiting resulted in World War I in imprisonment. Processions for the presentation of petitions in the United States have not been particularly successful. In 1894, General Coxey of Ohio organized armies of unemployed to march on Washington and present petitions, only to see their leaders arrested for unlawfully walking on the grass of the Capitol. See the trickery of all these guys? Oh, you can't walk on the grass. You're going to get arrested for that. I think that's God's green earth. I don't know. I mean, you see the corruption throughout history when you start reading some of this stuff. The March of the Veterans on Washington in 1932 demanding bonus legislation was defended as an exercise of the right of petition. The administration, however, regarded it as a threat against the Constitution and called out the Army to expel the bonus marchers and burn their camps. Marches and encampments have become more common since, but the results have been mixed. So, the thing is they always want to go against us and say that we're the ones that's attempting to overthrow the government, which we have every right to do. Obviously, not for light and transient causes. But if we have the right to alter, reform, or abolish anything at any time we deem it necessary, it's all about the language. We regard this as a threat against the Constitution. How about it's a threat against our rights? And that's internal insurrection. That's domestic violence. And then that, again, domestic violence about internal insurrection is an attempt to overthrow the Constitution and war against the people. And that's exactly what they are doing all throughout history. Nothing new under the sun here, folks. Okay, the right of assembly. This is under their doctrine on freedoms of assembly and petition. The right of assembly was first before the Supreme Court in 1876, United States versus Cruikshank. The Enforcement Act of 1870, so now we're getting into the corrupt stuff, forbade conspiring or going onto the highways or onto the premises of another to intimidate any other person from freely exercising and enjoying any right or privilege granted or secured by the Constitution of the United States. Defendants had been indicted under this act on charges of having deprived certain citizens of their right to assemble together peaceably with other citizens for a peaceful and lawful purpose. Although the court held the indictment inadequate because it did not allege that the attempted assembly was for the purpose related to the federal government, its dicta broadly declared the outlines of the right of assembly. The right of the people peaceably to assemble for the purpose of petitioning Congress for a redress of grievances or for anything else connected with the powers or the duties of the national government is an attribute of national citizenship and as such under the protection of and guaranteed by the United States. Gee, that sounds just like Article 4, Section 4, and my petition here. That's what I'm trying to do, folks. Almost verbatim exactly what was just said there. The very idea of a government Republican form applies to the right of the part of its citizens to meet peaceably for consultation in respect to public affairs and to petition for a redress of grievances. Does anybody want to join me in? Do you have a grievance about this foreign invasion, folks? You're going to get a chance to sign this petition. And I've already talked to my guy over here that does my website there, and I was hoping to get that done today, but I just too much going on at the office today. I didn't get it done, so try again tomorrow. But it'll be up on my website here shortly. Once I get this all done and propered and sent over to him and get the DocuSign set up, it'll be on. It'll be on the website, and you'll be able to click on the link and sign this sucker. And now that I figured this out, again, thanks to Derek Gonzalez and his wife over there, how to do the digital signature stuff, I'm going to be pumping out some petitions, folks. This is our republic if we can keep it. And at this particular point, I get that most people don't have the time to go learn this stuff and do this stuff, so I'm going to do it, and you can just get on board with supporting it. Okay? I hope you're all okay with that. Well, you most definitely won't be the first to sign it, whoever you think you are out there. First of all, it's going to be me that signs it first. And there's going to be a couple of other people like Jonathan that's going to be one of the main ones that signs it first, because he's the one that I'm working with on this petition and has all the evidence. So keep that in mind, folks. What this petition is really about, and based on Jonathan's work down on the border and the evidence that he already has. Okay? And more than likely, Jonathan and I are going to have to go out, visit Congress, and lay all this out, because that's how this works. So, all right, back to this over here. The very idea of government alleges that the counts the objective of a meeting. If it had been alleged in these counts that the object of the defendants was to prevent a meeting for such a purpose, the case would have been within the statute and within the scope of the sovereignty of the United States. Absorption of the assembly and petition clauses into the liberty protected by the due process clause of the 14th Amendment. We don't need your 14th Amendment. The right stands by itself, and the due process of law clause is not the 14th. This is all garbage. Reconstruction Acts era stuff. Right? It says privileges. It doesn't say rights. And again, as we've already discussed and found and read, that this right goes clear back to the Magna Carta, Chapter 61 of 1215. Are you telling me that the 14th Amendment somehow strengthens this or, gives it credence? I don't think so. We don't need the 14th Amendment for our right to petition. Been around way longer, hundreds of years. Yeah, I agree, Leslie. We all need to learn how to do this. But Like she says, we have to take advantage of my knowledge right now. Time is of the essence. Absolutely. So essentially, once I get this sucker up, it's only going to be about 2 weeks, about all the longer I'm going to wait, and I'm going to get this sucker filed because this needs to be done without delay here. Means that the Cruikshank limitation is no longer. Uh-oh. What the heck just happened? Wow, my whole computer just glitched. Oh, of course, OBS doing the recording over there decided to crash. Of course, go OBS. And it looks like Zoom, everything is locked up here. Can you still hear me out there, folks? Okay, so Telegram, you probably made it through, but I don't think anybody else did. Oh, everybody's still? Okay. It's not showing that it's working over here, so it's not picking up any audio. Okay, so Facebook's still going, YouTube's going. Okay. Well, I'm going to keep rocking then. No, it's the recording that I was using to record, I think, is what actually caused the problem. So, anyways, all these videos are out on the channels. So, again, Rumble, YouTube, and Facebook. And then usually I share the Rumble video on Telegram once it's done compiling. All right, so today the right of peaceably assemble is, in the language of the court, cognate to those of free speech and free press, and is equally fundamental. In 1937. Woo, in 1937, huh? Again, this right of petition and our form of government type stuff, they've been around for a long time. We don't need the judicial branch to articulate this stuff for me, so I don't know what the heck the deal is, but, you know. I do see that my video has quit working. So I wonder if I just close that and then reopen if it fixes it. Nope. But anywho's, we'll just keep rocking over here. Let's see. Broadly, the court has said that the government may not prescribe peaceable assembly for lawful discussion, and even though participants may have committed crimes elsewhere, mere participation in a peaceable assembly and a lawful public discussion may not provide the basis for a criminal charge, absent evidence that their speech transcended the bounds of the freedom of speech which the Constitution protects. So this is the thing, folks. We have this right, and it specifically does state in the First Amendment that Congress shall make no law respecting the establishment of free speech, or of religion, the free exercise of religion, as well as speech and press and right of assembly and the right to petition. They have no authority over that because all of that stuff comes from the common law. It's already the law, long antecedent to the formation of government. Sehill versus Hinkle reiterates that our rights are long antecedent to the formation of the state. So, I really don't think I need to. Furthermore, the right of petition has also expanded beyond what might be implied by the language of a redress of grievances. For example, the Supreme Court has recognized that the clause protects the right of access to the courts beyond just a right to petition the legislature. Absolutely. There are writs of review, sometimes referred to as writ of certiorari. There's writ of prohibition, writ of mandamus, where, oh, geez, that's right. Those are those mandates. Writ of mandamus from the judicial branch to a lower inferior court to instruct them to do a thing, or to instruct a public servant to either do or refrain from doing something as a judicial mandate. But those are all common law writs. So, pursuant to the common law, for these, like writs of habeas corpus, writs of quo warranto, writs of certiorari, okay? Yeah, those are done through the judicial branch. I get that. But when it comes to petitioning for the redress of grievances, that is done specifically through the legislature and only the legislature. Because like it says, beyond just a right to petition the legislature, no, because the right dictates that it goes to the legislature. You know, that's the thing. The right dictates this, folks. You know, you need to find this in your own state, but it's a right. It doesn't matter where it's enumerated. Right of assembly, the people shall have the right to assemble in a peaceable manner, to consult for their common good, to instruct their representatives, and to petition the legislature for the redress of grievances. The right dictates this. Okay? Some states will say the right of petition, remonstrate, and address. So this is why we need to learn what our rights are, and then, you know, the same thing here in Idaho is in everyone is that reserved rights not impaired. There's always this clause in there. This enumeration of rights shall not be construed to impair or deny other rights retained by the people. Notice again that it says the people, not American state nationals. I've yet to find any kind of verbiage like that in any Bill of Rights, anywhere. Because it doesn't exist except for through the Roman civil law, the code, and didn't come into being until 1878. After that, Reconstruction Acts turned us back into a monarchy. And a national is a citizen of the United States under the code. Anyways, that's just the way it is in the letter of the law. So, as we can see, that's how this works. So, when you find a right that happens to be enumerated in some other supposed constitution, when it's actually a Declaration of Rights, and seeing this as part of that fundamental alteration, they've moved the rights in with the Constitution to give us the illusion of constitutional rights instead of constitutionally protected rights. Because Again, the Declaration of Independence. Right here. That to secure these rights, which means they had to have exist before the government is instituted among men and before they're divested with their just powers from the consent of the governed. And then see, here it is, that when any form of government becomes destructive of these ends of securing our God-given rights, it is the right of the people to alter or to abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. So, even it says, prudence indeed will dictate the governments long established should not be changed for light and transient causes. Okay? And then, accordingly, all experience hath shown that mankind are more disposed to suffer, while evils are sufferable, than to right themselves by abolishing the forms to which they are accustomed. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty to throw off such government and to provide new guards for their future security. So when they say, oh, you're trying to overthrow the government, the illegitimate, the unlawful, but see, you have to know this. What is Republican in character and conduct? What is within the meaning of Republican form of government? I can give you a list of things, of characteristics and conduct of a tyrant. That's what these are. Because let these facts be submitted to a candid world. Are you paying attention? That the history of the present King of Great Britain and a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. This is where we're at again, folks. And these are declared acts of tyranny. This is characteristics and conduct repugnant to our republic. Just saying, folks. Here in the end, right? In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. Wait a minute, this is 1776. Isn't that what was going on back here? Yeah, in 1689, the same thing. So from 1689 to 1776, it just happened again. So this is what I'm getting at, folks. With all of this that I'm trying to learn, exercise, and then teach my fellow man to do here, is that we can't claim that we are under absolute despotism until we claim and exercise this right. Till we petition, till we remonstrate, and tell them, no, you don't have this authority, and I'm instructing you. Okay? Cannot claim absolute despotism unless we do this due process of law. And now here's one right here. He has excited domestic insurrection among us as endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. Would that be some of that foreign invasion that's going on right now? Are they bringing in these guys, these men, military-aged men, to wreak havoc on us? Just saying. Better be paying attention out there, folks. Right? Good one. Mark Mon out here on YouTube. Honest Abe suspended the writ of habeas corpus, and so did Bush. For specific reasons. But Attorney General Barr says the Constitution is never suspended, and especially not during a time of crisis. Absolutely. You can't suspend the Constitution because it's the instrument of government that creates everything. And without that, you suspend the Constitution, there is no government. And how can the servant suspend the laws of its own creation? That goes right back to the law of nations. That none of these guys can do that. Even the legislature can't alter the laws of its own creation. They can't alter the fundamental law or the Constitution. They're not supposed to be able to. See, this is what we need to understand. A question over here. I'm telling you, isn't the Constitution suspended now because the corporation is dissolved? No. See, this is where we have to understand what Trump did when he did his proclamation, reestablishing the rule of law. You know, maybe that's a really good one to bring up right about now. Because I think this might actually make sense now. Applying this right now. Let me see if I. Where is it? Proclamation on paper guidance documents. That's Executive Order 1381. 13818. Mandamus. Where is it? DOD Law of War Manual. I thought that I put these all in order, but maybe. Oh, there it is. Okay. All right, so this is the proclamation from December 10th, 2017. As Human Rights Day, December 15th, 2007, as Bill of Rights Day, and the week beginning December 10th, 2017 is Human Rights Week. Okay? Our great country was forged in the fires of a revolution to overthrow the rule of a tyrant by a free people who understood the fundamental truth that liberty is best secured when the state's power is carefully limited. From the Declaration of Independence to the Constitution and through the Bill of Rights, our country and our people have always known the true, God-given nature of liberty and the ability of law to safeguard it against the state. For 226 years, the final piece of this freedom-sustaining bulwark, the Bill of Rights, has formed the bedrock for the Constitution protections every American holds dear as their birthright. The Bill of Rights. That's right. The Bill of Rights, when we read the Bill of Rights in its entirety in the very beginning of it, it says that these are articles in addition to an amendment to the Constitution of the United States of America. All right. So, if it's a Bill of Rights, it most certainly applies to all of the states because these rights are long antecedent into the formation of the state. It's just merely declaratory of the common law. See American Jurisprudence, Volume 16, Constitutional Law, Section 100. We hold these dear as their birthright. And their constitutional protections. That's right. These rights come from God-given, from the laws of nature and nature's God. So, on Bill of Rights Day, we recognize the importance of the first 10 amendments to our Constitution to protecting our liberty and freedom against the inevitable encroachment of government. And it's not the first 10 amendments. That's one amendment. The entire Bill of Rights is one amendment. Those are articles, because this is contract law. Contracts are written in articles. So our founding fathers understood the threat of expansive, omnipresent government. From the beginning of our republic, therefore, they endeavored to enhance the Constitution with the Bill of Rights, a specific enumeration of fundamental rights that would prevail even against a future government inclined to abuse the power it has over the lives of citizens. On June 8, 1789, James Madison, originally skeptical of the need for a Bill of Rights, introduced in the Congress several amendments to the Constitution that would eventually form the Bill of Rights. Now, I'm not sure how many people are aware of this, but there was about 157 different articles supposedly in this Bill of Rights. And there was so many rights that one of the argument against the Bill of Rights was that there was too many rights to enumerate. It would be impossible to enumerate them all. And then if we enumerated some, that the government might construe that as though those are the only rights we have. So, let's continue reading Trump's proclamation. During the ensuing debates, Madison told the Congress that because all power is subject to abuse, it was worth taking steps to ensure that such abuse may be guarded against in a more secure manner. Many of the rights set forth in the amendments Madison introduced that day are quite familiar to us as Americans. The right to worship as we please, the right to speak our minds and consciences, the right to firearms to protect ourselves and our loved ones, the right to be free from unwarranted government searches and seizures, the right to a jury of our fellow citizens when accused of legal wrongdoing. Others, like the right to object to housing troops in our homes during peacetime, are often thought as relics of a bygone era. Regardless of their familiarity or applicability to our daily lives, however, each clause of the Bill of Rights addresses profound and real abuses the founders faced, and each is crafted and locked into law to protect us and future generations from their repetition. Since its adoption, the reach of the Bill of Rights has spread far beyond America's shores. As George Washington rightfully said, liberty, when it begins to take root, is a plant of rapid growth. For example, in the wake of the devastation of World War II, the spirit of the Bill of Rights inspired the United Nations General Assembly to adopt the Universal Declaration of Human Rights in 1948. Garbage. Just like the Bill of Rights, the Universal Declaration of Human Rights is grounded in the recognition that just governments must respect the fundamental liberty and dignity of their people. That UN is a bunch of garbage created out of California, by the way. And of course, they've got loopholes in their Universal Declaration of Human Rights. But again, do we really need this written down on paper for it to exist? No, because we're talking about the laws of nature as fundamental law. It's supposed to be self-evident. It's in the law of nations. Imagine that. Regarded as international law. But by enumerating core rights that should be immune from government encroachment, both the Bill of Rights and Universal Declaration of Human Rights have helped fuel remarkable prosperity and achievement around the world. So, during Human Rights Day, Bill of Rights Day, and Human Rights Week, we rededicate ourselves to steadfastly and faithfully defending the Bill of Rights and human rights. Our God-given fundamental rights are soon overcome if not safeguarded by who? The people. Not government. The people. We, therefore, also reflect upon the many individuals who are unable to enjoy the God-given rights that we as Americans know are secure. Right? We remember those suffering under the yoke of authoritarianism and extremism for doing nothing more than standing up to injustice or daring to profess or practice their religion, and we acknowledge those imprisoned or in peril simply because of their political views or their sex. Now, therefore, I, Donald J. Trump, President of the United States of America, by virtue of the authority vested in me by the Constitution and the laws of the United States, do hereby proclaim December 10th, 2017 as Human Rights Day, December 15th, 2017 as Bill of Rights Day, and the week beginning December 10th is Human Rights Week. Now pay attention, folks. I call upon the people of the United States to mark this observance with appropriate ceremonies and activities. Appropriate. We should be celebrating our God-given rights and freedoms from governmental infringement every year now. But this is Trump. December 10th, 2017. Okay? So now you know. Reiterating the rule of law here. All right, so this political power that's inherent in the people, okay? Ooh, no. Whew. Good thing I didn't do that. Right here, national-assembly.net, okay? This is where we're coming together. We, the people, the real government de jure is being reassembled. This is the only legitimate avenue for doing this. This is the legitimate way. Okay? Again, I've been down several rabbit holes for years on this, and this is the legitimate one. These guys have the military support. Nobody else does. And a little more than just support. Okay? Now, I know this finally got back up. There was a little bit of issues going on there, but where was that? Do you have that on there where it talks about... Yeah, here we go. What have these guys accomplished, right? Michigan settled as de jure state interim in 2013 and recognized by 7 foreign countries. issued 21 requisitions to Joint Chiefs, Judge Advocate General, and the Pentagon, 12 of 2011, resulting in putting Trump into presidency, Space Force, and much more. Stopped Obama from going into Syria with boots on the ground September 10th, 2013. Voiding the Act of 1871, causing the Queen to lose her power, and walking behind Trump and Trump inspecting the Queen's military. Act of 1871 voided, rendering D.C. as a dead foreign crown-owned Vatican-run city-state, and our country defaulted to military control and became a foreign-occupied territory. Alaska, with unwedded but original nation state, settled November 5th, 2020. Anybody else out there can claim anything like that? And this is it. The only thing they've ever seen from other groups is people getting nowhere and ending up in jail. Be very careful with people out there that, oh, you need to do this, or we're assembling our grand jury, and we're doing this, and we're doing that, and none of it's lawful. You're going to get yourself in trouble. Just saying. Because when the military comes in, because make no mistake, it's happening, it's coming, to take down the corruption. Pursuant to Executive Order 13818. Now, there's all sorts of great stuff you can look at on here. Jason from his Hardline out here has done quite a few different podcasts. This is over on Podbean, and you can listen to it right here on the website, reiterating some of this stuff. And Oscar, he did some really good stuff over that military manual on citizenship. Now, I know that that's a word there that's a kind of a trigger word for some people. But Thursday nights, we do a conference call over here. Here's the information for that. 6 p.m. Pacific, 9 p.m. Eastern. And you can download the free conference call app on your smartphones. Here is a YouTube video how to do that for your smartphones. Here's a tutorial video for the desktop app. And then here's the link to join the call. So I highly recommend downloading and installing the app, whether it's on your desktop or it's on your smartphone. It's so much easier to use than just dialing in. Now, I get that there's some people out there that don't really do much for internet, and all they do is, I know a gentleman right now who has a flip phone. He doesn't have a smartphone, and he doesn't have internet. So those kinds of people do exist out there. Kind of odd in this day and age, but some people just don't like that stuff. Right? So, this is where we're meeting here on Thursday nights. And, this here National Assembly, national-assembly.net, is about education. It's not an actual National Assembly. That's just the name of the school here, right? So, don't want people confused, because we can't have a National Assembly until we reassemble government de jure in the state assemblies, the General Assembly. We can't have a common law grand jury until we reassemble the General Assembly. The General Assembly has to be assembled first before anything else can be created. So I know this is a hard pill for a lot of people to swallow out there, but that's the truth. That's the facts of law, the way it works, the law of creation. You have to create the thing first. You have to create the sovereign body politic, which is the General Assembly, which is composed of the body of the people themselves. And without the sovereign body politic, you can't create anything else. That's just a fact, folks. Whether you like that or not is irrelevant. So, until we can reassemble, which my understanding last week, while I wasn't able to be on there because I was actually live with Just Jody there over there on Patriots Helping Patriots, getting out the petition stuff. But there was 30 states on there. Now we haven't done settled them yet, but very thankful to hear more people getting on there, and we need to get this stuff done. And the sooner the better. The sooner we can get 34 states' general assemblies assembled and declared and settled and all that, then we can talk about having a national assembly. But until then, we can't even begin to talk about a national assembly. We can't have a constitutional convention because who are the delegates selected by the General Assembly are you going to send to be in Congress? So essentially right now, folks, we don't even have a government. This is all under continuity government, under the 2 federal directives, and the military's in charge, and we are under martial law, whether people realize this or not. And, Texas v. White, Article 4, Section 4, this is Trump setting up provisional government pending the outcome of the war. As commander-in-chief, there is no president. That corporation's a done deal. Gone. Involuntarily bankrupt and foreclosed on. So, there's some more resources here. There's the training manual right here, TM 2025. That's a military training manual. 10 steps to assembly. Here's a handbook. There's all sorts of good stuff here. Okay. Public notices. But yeah, here's our current situation. Where are we the people? Where are we? It's up to us, people. Now, is it going to let me turn my video on? All right. I wondered if I gave it a relax. No, not Mark out here. Not 28 USC 3002-15A. Get rid of the United States Code. That's not law. That's all Roman civil law, folks. Quit citing United States Code. Code of Federal Regulations. Uniform Commercial Code. Code is not law. Law is spelled L-A-W. Code is spelled C-O-D-E. Do you even know the difference, folks? Like I said before, earlier, folks out there, need to change their source of law. Start reading the Law of Nations. That's international law. Start studying the laws of nature. My brother Rob, which I haven't seen him on here tonight, he's been reading some stuff, finding some stuff, finding some pretty good stuff out there. So, telling you folks, we're headed back to our true republic, and it's up to the people. Right here, drain the swamp. It's up to the people to do this. Nobody else. And at this particular point, the word is if we don't hurry up and reassemble government de jure, we'll be under martial law when they come in and wipe out the bad governmental regime. Plain and simple. We'll be stuck under martial law until the people reassemble. That's that all political power is inherent in the people. We have to reassemble. There is no other way around this. Well, technically speaking, Mark, there isn't any real statutes anymore. It's all code. No. Blue sky out on YouTube. No, the first step is not to repudiate the debt. The first step is to reassemble government de jure. That's the first step. And that's where the people take back their power, the right to alter, reform, or abolish anything at any time we need it. We deem it necessary. You need to learn this stuff, folks. We got to get back to the roots, the basics, the fundamental principles. We're going to build this thing. You got to start with the first thing first, and it's called the General Assembly. That's what comes first, before anything else. Need people to fully comprehend and then understand this and gain the wisdom that we need to have to do this. It takes the people coming together and assembling the General Assembly first. Okay? Hope everybody gets that. I mean, I keep reiterating this on a regular basis now, and hopefully it sinks in. I know some people's heads are harder than others, and it takes a little while. But repetition is the key to all this, hearing it over and over and over and over. We have to reassemble the General Assembly first. We cannot do anything else, governmental-wise, until we do that. Plain and simple. That's the law of creation. You know, if we're going to create this thing, you have to have the people assembled. Got to have the sovereign body politic. Again, that's Book 1, Chapter 1, Section 4 of the Law of Nations. I don't know how to make it any more simpler than that. And again, the only legitimate, lawfully assembled ones is through the national-assembly.net. And unfortunately, for those of you that out there that think you needed to do your repudiation and declare your status as an American state national and all that stuff, you're exempt because you're a foreigner. You actually put yourself back in under the crown, the ones we've been trying to get away from, the deep staters, and put yourself back in under that. You can thank those that duped you into doing all that stuff. And until we properly reassemble and reestablish the republic, you can't be a part of this because you're a foreigner. Your allegiance is to the crown. That's what you did when you did all that paperwork. You just don't realize it because the wool was pulled over your eyes and you were deceived because of your own lack of knowledge. That's the problem. Nobody did their own research like I did, and I called it out. I didn't do any of it. Okay, Chubby King out here on Telegram. Do you have to send paperwork in or just start it? You have to join your fellow people and reassemble the General Assembly. Yes, there's some paperwork that needs to get done. Okay, but it's nothing like doing the other people out there. I don't even want to mention their names, but all this repudiation and all that. No, that's not the kind of paperwork we're talking about. Okay? I am man, creation of God. I don't need to change my status to anything else other than becoming one of the people, having political power, claiming my political power, claiming my political rights as one of the people. Not American state national. It's people. All political power is inherent in the people. Not American state nationals. Not anything else. Okay? Again, from the law of nations. Regarded as international law. It applies to all settled civilized nation states. Okay? This is just how it's done. So, this doesn't have anything to do with Russell J. Gould. Doesn't have anything to do with anybody out there other than the people, folks. Wake up. Kick all that garbage to the curb and focus on what needs to be done, which is reassemble the General Assembly. That has to come first before anything else. I don't care what one man has done out there. That's not how this works. You got to have a General Assembly, the sovereign body politic. They're the ones that create the instrument of government. The General Assembly. Did you guys know that? There is no legislative branch. There is no executive branch. There is no judicial branch without the General Assembly creating it. That's what the Constitution does. And that's created by the people themselves. The General Assembly. So we can't create the Constitution, the instrument of government, until we reassemble the General Assembly. Got to be first, folks. There is no way around this. Absolutely no way around this. While I might be trying to do this petition stuff and deal with what we have right here, right now, which is a continuity of government, and they do most certainly have to discharge the duties pursuant to the Constitution. That's the rule of law. And this goes to the military. But there again, this is claiming and exercising the right of petition. Okay? So, again, reiterating again, we have to reassemble the General Assembly to ultimately claim our political power, the right to alter, reform, or abolish, like it says in the Declaration of Independence. It's not just a right, it's a duty. So come on, folks. Get over there on the National Assembly call. Get on the website, national-assembly.net, and start reading and studying that stuff and get active and get involved on the call. And if you're new, during the Q&A, I got to quit. Hey, I'm from so-and-so. Can you connect me with the coordinator or moderator? Where can I make contact? Like, I'm supposed to be the coordinator for Idaho, but I get one or two people that are interested. So we need to be having some meetings here. Just been busy, folks, as if you can't see already. But Greg, out here on YouTube, are we referring to individual state assemblies or an American General Assembly? No. General Assembly of a state. See, those are countries. They have a flag and a governor. That's a country. Right out of the Law of Nations, that a nation is composed of all the countries. See, this state of garbage is under the Vatican, a corporation. And see, that's what's been taken down, folks. So again, we don't even have any kind of real government. It's all just willy-nilly out there right now. We need to take back our power. And the only way to fully claim and exercise that power is reassembling the General Assembly in each country. Okay, we need 34 countries within this nation called America to become active. In the end of all this, if we don't hurry up and get that done, well, the territories that haven't reassembled their General Assembly for the territory is going to be under martial law until they do. So it would behoove us to kick our butts in gear and start talking to your fellow man in your local area and get some people together and get the General Assembly assembled and declared and settled in interim. Now, I know that we're being infiltrated over there because they don't want this. The deep state wants to win. They want the new world order, the one world government. That's the Vatican. That's, it is what it is. The Tri-City States, that's right, the Vatican. Yeah. DC, which is no more, right? That's done. Again, go look at Google Maps. DC is not there. Washington, yes, but it's no longer called Washington, D.C., District of Columbia. Not on Google Maps. I've already looked. It ain't there. Been wiped off of the maps. That's because it's no longer District of Columbia. January 20th, when that all went down, when the military came in, that's pursuant to the Law of War manual, right out of the Law of Nations under War and Peace. And right there, what I was just reading from tonight, it's up to the president to determine which is the lawful government and which one's been afraid against. Up to the what? As commander-in-chief. That's right. And that became a foreign occupied territory when they didn't give it up. So Trump had to send in the military because this is military law outside of the Constitution, folks. Many people don't get this, that there's a body of law that's outside of the Constitution, the Law of Nations. Okay? And again, the military subordinate to the civil power that's been around since 1553 with the merchant marines, the civil power, long before our founding here in 1606 with the first Charter of Virginia. 53 years before. So, that's just the way it is, folks. That's the real law stuff. That's the way it frickin' works. And, well, we got to do this, folks. We need to reassemble the General Assembly so we can take back our power. And again, these guys are the only legitimate ones out there. These back in Michigan where Carl Miller started at with all this. Okay? That's the reason why I know, one of the reasons why I know that this is the legitimate one. The ones I've been looking for since I found Carl Miller's videos clear back in 2012. It's Project Blue Book. That's where all this stems from. And that manual there, the training manual. Okay? Trying to get people to learn what their rights are and how this form of government works and who has what powers and, just how all this functions like an internal combustion engine. An internal combustion engine is not going to run very well if it's out of time. It's not going to run very well if you don't have a connecting rod in there connected correctly. Okay? This stuff has to be put together correctly in order for it to run smoothly and run correctly like a well-oiled machine. All right? So much love. God bless everybody out there. Thank you for tuning in. like, follow, and share. And again, with donations, get over on my website there. Here, I'll pull that back up real quick. It's going to work. Right here, the links to my stuff. I got Facebook page, my Telegram channel, Patreon, YouTube, and Rumble. Now, if you want to get over there on Patreon, because again, more than 2 years ago now, they took down my PayPal and Cash App and Venmo. I don't have anything set up for digital donations except for through Patreon. Okay? And then you can do whatever you want. Tier 1, Tier 2, set up for $5 and $10 a month. You can do whatever you want. Tier 3 gets you into Wednesday night workshop. This one right here, that's where that talks about that there on Patreon. And then Tier 4 is the one-on-ones. Now, if you want to send any postal money orders, regular money orders, cash wrapped aluminum foil, gold, silver coinage, anything like that, send it over to me to the office and make it out to me. Kirk Pendergrass, and there's the address, 6477 West Fairview Avenue, Suite C, as in Charlie, Boise, Idaho 83704. Okay? So I want to thank those that in the past have supported, but would greatly appreciate some more support here as this is going to take off, and Jonathan and myself are going to have to go to Washington to talk to some sort of a committee on this and present this evidence about the foreign invasion and the drug trafficking and the human trafficking. Okay? So, Jonathan has his donation links up for him on his stuff, on that livebordernews.com stuff. So, but other than that, thank you all for being here. And I will definitely come out and let everybody know when that happens, that this is on my website